My name is Natalie McClendon. I am responsible, or you can blame me, for this forum. Um, we have 9 candidates tonight, and because there's so many candidates, I hope you think of this as just the start. We're scratching the surface, and I also hope that other organizations will be inspired to step up and do more forums before the primary. I want to thank Jessica Levin, who will introduce herself in a minute, um, for helping us pull this off because, frankly, I had no idea what I was getting into when I said, "Oh, let's just do that." So, go ahead, take it away, Jessica.
Thank you, Natalie. Good evening and welcome to this Washington Supreme Court Candidate Forum. Thank you to our candidates and to everyone joining us, both in the in-studio audience and as well as online. And thank you, of course, to Natalie McClendon and the Yakima County Democratic Committee for hosting this important event. As Natalie mentioned, my name is Jessica Levin. I direct the Center for Civil Rights and Critical Justice at Seattle University School of Law, where I teach our Civil Rights Clinic and teach, research, and publish on various topics of state constitutional law. This is an unusual and important moment for our state. Tonight, we have hopefully 9, if Judge Mamilo ends up joining us, but 8 at the moment, candidates competing across 4 separate races for seats on the Court of Last Resort in Washington, a court that interprets our state constitution, that shapes the development of our common law, and that reviews the legality of actions taken by the legislative and executive branches. The individuals you will hear from tonight are seeking positions that carry profound responsibility to decide cases impartially, to safeguard constitutional rights, and to maintain public confidence in our system of constitutional democracy. Here's how the program will work. Each candidate will begin with a brief opening statement. We will then move into a series of moderated questions. Most questions will be directed to all candidates, while another specific segment involves a set of questions where only the candidates within a specific race will answer that question. Time limits will be enforced to ensure equity and to allow us to cover a wide range of issues, including judicial decision-making, constitutional interpretation, and access to justice issues. We will conclude with brief closing statements from each candidate. We ask that the candidates keep their responses within the allotted time and know that given the nature of the judicial office, we will not be asking questions that require candidates to comment on cases or issues that could come before the court. That constraint is part of the ethical framework governing judicial conduct. We encourage our audience to listen carefully for how each candidate understands the judicial role, how they reason through legal questions, how they view precedent, and how they approach the balance between stability and change in the law. Before we begin, I want to take a moment to explain how judicial elections for our state Supreme Court work. These positions are nonpartisan and have specific statutes that govern the election process. The Election Division of the Secretary of State has published a helpful memo explaining how the top 2 system interfaces with the specific statutes that govern nonpartisan elections. So the information I'm providing is taken directly from that memo. The first thing to know is that there is no primary if there are only 1 or 2 candidates for a particular position. If there are 3 or more candidates, all candidates will appear on the ballot in the primary election. As with any other race in Washington, the top 2 advance to the general election. However, if races of 3 or more candidates for Supreme Courts, or if there are 3 or more candidates for a particular position, if a candidate in a contested primary receives a majority, so 51% of all the votes cast, there's a specific statute that requires only that name to be printed on the ballot for the general election. So the second thing to know, apart from those details, is that we are not past the filing deadline of May 8th. So a current 1 or 2 candidate race may end up on the primary if more candidates file. So thank you again to the candidates for participating, to our hosts, and to each and every attendee this evening for engaging in this very important civic process. So with that, let's begin with opening statements. I've asked each candidate in their opening to address their judicial philosophy and address how their background and experience shape how they approach the work of Supreme Court justice. Each candidate will have up to 2 minutes for this opening. And as I explained before we started, I'm grouping candidates by the position they're running for. And for opening statements, I'll begin with the names within each position alphabetically. And then for subsequent questions, I will change the order both within each position and among the positions. So at 50 seconds left, the candidates will see a timer turn yellow. I don't think the audience will see this, but know that all candidates will have that timer going. And when 2 minutes is up, we will ask you to wrap up your answer and move to the next candidate. So with that, proceeding with position 1 first, I'm going to ask Mr. Edwards for the opening statement.
Am I ready to go?
You are.
Good evening. Thank you for the opportunity to be here tonight. I appreciate the chance to meet with people who care about fairness and public trust in our Washington courts. My name is Scott Edwards, and I'm running for the Washington State Supreme Court because I believe our highest court must be a place where the law is applied fairly and thoughtfully, as written and in accordance with the Constitution, without political posturing. I was born and raised in Anchorage, Alaska, where my grandparents opened a restaurant that has become a local institution, the Lucky Wishbone. I started working there when I was 14, and by my senior year in high school, I went to school in the morning and then worked an 8-hour shift, 5 days a week. I understand the value of hard work and will work hard on the Supreme Court for all Washingtonians. I've been practicing law in this state for more than 30 years, representing individuals and businesses large and small throughout the state, helping them to understand and pay the taxes they owe, while also helping to make sure that the government applies the law as written, fairly and consistently. Throughout my legal career, I've had the privilege of seeing the justice system from multiple perspectives. I've worked on complex legal matters, studied the law carefully, and built a reputation for preparation, professionalism, and integrity. In addition to my legal practice, I've also been teaching at the University of Washington Law School for more than 20 years, where I help to educate the next generation of lawyers. I've spent years solving difficult problems, weighing competing arguments, and understanding that good decisions require patience, discipline, and respect for the facts. That experience matters. The role of a Supreme Court judge is to interpret the law faithfully, protect constitutional principles, and treat every person who comes before the court with respect and fairness. I'm running to preserve judicial independence and ensure that justice in Washington remains fair, impartial, and worthy of the public's trust. Thank you.
Thank you, Mr. Edwards. And Justice Melody.
Hi, good evening to everybody. Thank you to the Yakima County Democrats for hosting the forum, and to Natalie and to Jessica for helping put it on. So I'm privileged to currently serve as one of your 9 Washington Supreme Court justices. I was appointed in January by Governor Ferguson. And before that, my entire career was as a civil rights lawyer. So I worked first for the U.S. Department of Justice in Washington, D.C., bringing civil rights cases all over the country. And then I came back home in 2015 to help build the civil rights unit that then AG Ferguson had started. And in that role, we brought cases all over the state, in every corner of the state, and alongside people from all walks of life when something had gone wrong and when there had been discrimination or unfair treatment in housing, at the workplace, in credit, insurance, at businesses open to the public, and by government. We brought police misconduct and jail cases too. And so I was appointed after that career, and now I'm running to retain my seat because we're at a point in this country where institutions are really being tested, and it's never been more important for us to have a real focus on state law. 98% of cases that are resolved in the court system in Washington are in state court. State courts must always be excellent and independent. Judges must be impartial and fair, and we have to treat everybody who comes before us with dignity and with a goal of increasing access to justice for everyone. And so that's really, to my judicial philosophy, the question that Jessica posed. It's really that we think about the real people who are impacted behind the decisions that we make, that we understand the impacts for, small businesses, for regulated entities across the state when we make our decisions, and that we keep that in mind, always respecting every litigant who comes before us. Thanks so much.
Thank you, Justice Melody. We'll move on to candidates for position 3, starting with Judge Diaz and then moving to Judge Hawk.
Great. Thank you, Professor Levin and the Yakima Democrats. My name is Mike Diaz. I'm a judge on the Court of Appeals and a candidate for the Washington Supreme Court Position 3. There are 3 things I'd like to tell you about myself just off the bat. The first is I'm a Latino immigrant of indigenous descent who grew up in the working class neighborhoods of Seattle. Second, I was a federal civil rights lawyer who defended the rights and freedoms of our most vulnerable, including from police excessive force, and who President Obama nominated to be a federal judge for that work. Third, I'm the only candidate in this field who's been both a trial court and appellate court judge. And for that, I'm supported by 3 governors, Inslee Gregoire Locke, Attorney General Nick Brown, 8 Supreme Court justices, including a majority of the current Supreme Court, nearly my entire bench on the Court of Appeals, and over 100 Superior Court judges around the state, including in Yakima. It's all listed on my website, diazforjustice.com. As to the first point, my family and I immigrated from Peru to Seattle when I was an infant. And to take a step further back, my dad was raised in the slums of Lima by a single teenage mom. And when he got here, he washed dishes, was a janitor, cleaning some of the buildings in downtown that I worked in later as a lawyer. My mom was a seamstress in Belltown and stocked shelves at Safeway. I can honestly say that my family has lived a version of the immigrant's American dream, a dream that is now under threat. And as to the second point, the core of that dream is giving back to the community, and I was honored to serve my country and literally represent the United States in court as a civil rights lawyer for the U.S. Attorney's Office in Seattle. In my decade there, I founded the Civil Rights Unit and led the reforms of the Seattle Police Department, which we put under a consent decree. That's the third point. Governor Inslee appointed me to be a King County Superior Court judge, where I tried dozens of cases to verdict and was in leadership. He then appointed me a second time to my present position in the Court of Appeals, where I've authored over 200 opinions. I'm in my 9th year of judging. This personal and professional experience guides how I would, shapes my judicial philosophy and how I would my work on the Supreme Court to ensure that it's an open bench to all people, including immigrants, and that we continue to follow the rule of law humbly and pragmatically. And so that is paying for the American dream to a new generation of Washingtonians wherever they come from. Thank you very much.
Thank you. Judge Hawk?
Good evening. I want to thank the Yakima Democrats for hosting this forum. I worked in Yakima when I clerked for a federal judge there, and I always enjoy returning to Yakima. I'm grateful to be with all of you this evening. As a Supreme Court justice, I will protect your rights and freedoms and the rule of law. I am Judge Jamie Hawk, and I am running for Washington Supreme Court Position 3. I want to start by telling you a little bit about myself and what has brought me here today. I was raised by a single mom, and I am the first in my immediate family to go to college. After graduating from Gonzaga University, I worked as an advocate for victims of domestic violence and sexual assault. Then I went to law school. After graduating from Gonzaga Law School, I began my legal career as an attorney fellow working with the U.S. Senate Judiciary Committee staff for Senator Ted Kennedy in D.C. I returned home to Washington to work on a juvenile justice reform project in Grant County as a public defender. Then I became a federal public defender where I protected individual constitutional rights when the federal government tried to take their freedom. I then did civil rights work with the ACLU of Washington. I was the first lawyer at the ACLU of Washington to become a judge in our state. I was appointed by Governor Inslee to King County Superior Court, where I currently manage a broad caseload of civil, criminal, and family law matters as a trial judge. I strive every day to ensure the promise of equal justice and access to justice is realized. Thank you for the opportunity to be part of the forum today.
Thank you, Judge Hawk. And let's move now to candidates for position 4, starting with Judge Burke.
Good evening, and thank you for having me. With 5 Supreme Court seats on the ballot this November and the rule of law under attack in our country, it's going to matter who we elect. My name is Ian Burke, and I am a judge at the State Court of Appeals, and I'm running for Supreme Court Position 4. I'm proud to be endorsed by the Aerospace Machinists Union, by Governor Jay Inslee, and by 30 appellate judges across Washington state who collectively represent all 39 counties of the state of Washington, including from Yakima, Judge Rob Lawrence Berry and Judge Megan Murphy. As a judge at the Court of Appeals, I've heard hundreds of cases affecting Washington consumers, families, and small businesses in every corner of the state. And I've written over 200 appellate opinions at the Court of Appeals. I was appointed to the court in 2022 by Jay Inslee. Before that, I spent 20 years as a lawyer representing individuals and small businesses taking on powerful interests, typically from insurance denials to workplace discrimination to consumer protection. I did cases all across Washington, including a 7-year class action in Yakima County, where we went to the Court of Appeals and made new pro-consumer law, and where I earned the endorsement of my then opposing counsel and now Yakima Superior Court Judge James Elliott. I'm a product of Washington Public Schools exclusively, including the University of Washington for college and law. All of those experiences shape how I see the law. From my years volunteering, representing tenants and consumers facing debt issues or housing insecurity, our laws need to work and be accessible for all people. At the Washington Supreme Court, I will ensure that we decide cases based on facts and law, never politics or pressure. I'd be honored to earn your support. Thank you very much.
Thank you, Judge Burke. And Judge O'Donnell, please.
Yeah, good evening, everyone. I'm Sean O'Donnell. I'm a King County Superior Court judge, and I'm running for position 4. The question was, what's your judicial philosophy? I always try to balance two things. The first is the letter of the law. What does the Constitution say? What do the statutes say? What do the case precedents say? And I balance that against the spirit of the law. And when I say spirit of the law, I mean, how does the law affect people? I've been a public servant for 25 years, and 13 of those has been as a King County Superior Court judge. I started out as a prosecutor in King County, and I prosecuted some of the most serious crimes in our community. I was one of the lawyers on the Green River killer case, and I prosecuted the first human trafficking case in Washington State. As a judge, I've sort of worn all the hats. I've been the chief family law judge in King County, the chief criminal judge. I'm currently the lead judge up at our Involuntary Commitment Act court at Harborview, and I'm the special inquiry judge. So they send me cases involving public corruption. I was appointed to that by my colleagues. As a judge, I've worked on many projects to help improve the judiciary, better courthouse security, more money for court interpreters, and improving our pretrial practices. And I've also worked to get guns off the street of King County, helping establish a protection order court. But your question on philosophy, being a trial court judge is the real difference, because I see people every day. They tell me about their families and the time that they want to spend with their kids. And any justice who goes up and makes decisions that affect all of the citizens of the state of Washington should have the people in mind when they make those decisions. Yes, precedent matters. Yes, the Constitution matters. All of that, rigorous analysis. But having people in mind in these decisions is critical. I'd appreciate your endorsement and your support.
Thank you, Judge O'Donnell. And finally, we'll move to our candidates for position 5, starting with Judge Amamilo. Welcome. You're muted. We're going to give you a moment where let's move to Justice Angeles, and we'll loop back to you.
Sounds great. Thank you, everyone, and good evening. Thank you to the Yakima Democrats for hosting this wonderful forum. I am your newest justice. I was announced as an appointee on March 9th, 2026. Before that, I practiced appellate, constitutional, and technology law for 26 years, and I had an exceptionally broad practice. I litigated civil rights and constitutional cases for both individuals and governments. I represented tribes and municipalities in challenging jurisdictional cases. I represented technology companies in investigating and targeting complex internet crimes. I litigated business disputes, family law cases, real estate conflicts, and one case is emblematic of my work. I represented an ICE detainee, a veteran who became a U.S. citizen while in custody. I sued ICE because they took a U.S. citizen and put him in jail for 7 months. I obtained $400,000 settlement and a formal apology for my client. And that case is now being used as precedent to show why judicial warrants and not administrative warrants are required for immigration arrests. My judicial philosophy is very simple. The people of Washington are best represented by justices who have deep experience with appellate courts and appellate issues. They need justices who are extremely hardworking, who dig deeply into the record and governing case law, and who do not come to office with an agenda. Now, why is the Supreme Court important? Because it decides the cases that are most critical for our rights and protections. It safeguards our rule of law. It protects our democracy from attack. And it also governs how technology will be used in our courthouses. I'm going to be the incoming chair of the Judicial Information Systems Committee. And one of our great questions is, how do we use AI effectively, ensuring the judges are not replaced by computers, but that our efficiency improves? I have a slew of great endorsements from the governor to the current justices. I would be honored to have your support, and I look forward to it. Thank you.
Thank you. Judge Amamilo.
Thank you. Can you hear me without an echo?
No, I'm hearing an echo.
Yeah.
Would you like 2 more minutes to try to figure it out? And we'll go to Judge Larson.
I think I'm logged in twice, so I need to figure out where the other hidden one is.
Okay, we're going to move to Judge Larson, and then we'll loop back to you. Judge Larson, please.
Hi, I'm Judge Dave Larson. I'm retired. I actually retired for 30 days before I decided to run again. I ran out of sense of duty, and I'm going to start a little bit different than the other folks, because let's start with people. Dignity and respect is as important to us as eating, breathing, and sleeping. And what the courts do, regardless of whether it's criminal law, civil law, we're always dealing with dignity and respect. And that's our number one product that we're supposed to deliver. But just under 30 years ago, I handled a wrongful death case. And that case taught me a lot in terms of how we approach the law, how we in the system don't recognize that basic tenet of humanity, that dignity and respect is most important. So for 30 years, I've tried to change the system. I first was civil law, and including making apologies inadmissible, as simple as that, to allow people to be decent with each other. Ultimately, I was of counsel for Williams Kastner, a large law firm in Seattle, handling litigation that you needed 25 chairs in a conference room to take a deposition. And I went from that to traffic and misdemeanors. I was a school board president, and the city asked me to come in. The court was making national news with controversy, and I helped fix that court. But it was a real eye-opener. Some students one time asked me, because I talked about my career, and they said, "You don't handle very important cases, do you?" And I said, "Actually, I handle the most important, because I can get people before they graduate to felonies." I developed the "I run a repair shop, not a junkyard" attitude, which have the courts have lives be better. One function of the Supreme Court that wasn't mentioned by Professor Levin is the fact the court is the prow of the ship when it comes to making rules, setting the tone for the courts. And we can do a lot of things on the Supreme Court if we focus on how we approach things, how we approach our rules. And right now the thing that's missing, and again, I like them all, I know them all, and I like them all, but the perspective of a trial judge and a trial lawyer. I was a trial lawyer for 23 years, handling lawsuits in federal and state court, and I was a trial judge for 18 years. Bringing that perspective to the bench, plus that sense of heart that we need to be able to truly have the trust and confidence of the people we're truly supposed to serve. And if we don't get back to understanding that the primary objective of us is to deliver dignity and respect in all that we do, we are going to continue to have some issues with the public in terms of having confidence in us. So trust and confidence is earned, and I want to be on the Supreme Court to help our courts, from the top to the bottom, have the confidence of the people of the state. Thank you.
Thank you, Judge Larson. And Judge Amamilo, let's see if we can have some good. Excellent.
Thank you. Thank you very much. The opening of this question is, what is my judicial philosophy, what's my background, and why the court matters? Good evening, and thank you for the opportunity to be here. I am Judge Sharonda Amamilo of Thurston County Superior Court, and it's an honor to be with the Yakima community. This region reflects so much of what makes Washington strong: agriculture, small business, and families who work hard and rely on a justice system that is fair, consistent, and accessible. And my judicial philosophy is grounded in a disciplined and consistent approach. Apply the law as written, remain faithful to the Constitution, and ensure that similar cases are treated similarly. I rely on a framework that I describe as FIRE: facts, issues, rules, and measured exceptions. We begin with the facts, grounded in the record. We identify the issues so the legal question is clear. We apply the rules, the Constitution, the statutes, and precedent, and only where appropriate do we consider measured exceptions, carefully and within the limits of the law that is allowed. That framework ensures that the Constitution is applied consistently in application of the law. My perspective is shaped by both my professional and personal experience. As a Superior Court judge, I have presided over thousands of cases across criminal, civil, family, and juvenile law. I have also served in the appellate function of the Superior Court, reviewing state agency decisions under the Administrative Procedures Act, work that carries impact across all 39 counties. In juvenile court, I have extensive experience with child welfare and rehabilitation, including cases involving ICWA and WICWA, which is the Indian and Child Welfare Act, and the Washington Indian and Child Welfare Act, and immigration matters such as special immigrant juvenile status, which often involve young people seeking stability and protection within our legal system. These matters require careful attention to state, federal, and tribal law, as well as a focus on long-term outcomes for children. My background also includes over 25 years in military intelligence. As a reservist in the United States Army, retiring as a Chief Warrant Officer 4. That work required discipline analysis, evaluating complex information, separating signal from noise, and making decisions grounded in facts and governing standards. That same discipline guides my work on the bench. The Washington Supreme Court matters because its decisions shape how the law is applied in every courtroom across our state. And for everyday people, that means its rulings affect public safety, stable families, economic opportunity, and access to fair courts. Trial courts rely on clear guidance, communities rely on fairness, and the public relies on a judiciary that applies the law consistently and independently. And my commitment is to uphold the Constitution, apply the law consistently, and ensure every person is treated with dignity and respect. And I am running for position 5 at sharondaforjustice.org. Thank you.
Thank you, Judge Amamilo, and thank you to all the candidates for your opening statements. So moving to the first question, I'd like to begin with a foundational question about the role of this court. State Supreme Courts operate in a different constitutional and political framework than the United States Supreme Court. Understanding those differences is essential to understanding how each candidate would approach the job of Supreme Court Justice. So again, in 2 minutes, I would like you to address the following question. What are the most important differences between a state Supreme Court and the United States Supreme Court? And how do those differences shape your approach to interpreting the state constitution? If in your 2 minutes you wish to include in your response an example of a significant state constitutional decision that you think was correctly or incorrectly decided, please feel free to do so. And we are going to go in a different order, as I indicated at the outset. So we will start with candidates for position 5. Let's start with Justice Angeles, please, and then we will move to Judge Larson and Judge Amamilo.
All right. Well, thank you, Professor Levin, again. This is an important distinction between our state constitution and the federal one. It's one that some ordinary voters don't understand, but it's something that I'm blessed to be able to describe and explain as we go across the state and talk to everyone. So just to cite a few examples, our state constitution has some special rights and special protections. Article 1, Section 7, for example, has an affirmative right to privacy, which does not exist in the U.S. Constitution. We have a special victims' rights provision in Article 1, Section 35, for example. And our state constitution in Article 2, Section 35, provides protections against certain kinds of exceptionally dangerous jobs. So understanding the context in which our state constitution differs from the federal constitution is fundamental to what we do every day as justices. We're going into a department this week. We're going to be deciding which cases we hear for the coming term and the term afterward. And the state constitutional issues that arise in every case are difficult. They're thorny. And although we keep individuals in mind, the cases we look at often have no clear answers, and we're addressing them in a unique concept. We have to look at what not only the language of our Constitution says, but what the 75 people who were the framers of our Constitution were talking about, thinking about, and trying to accomplish in the late 1800s when our Constitution was enshrined. And when we're talking about amendments, we have to be thinking about those circumstances as well. And at each stage, we have to ask ourselves, why does our Constitution differ from the federal Constitution? What were our framers trying to accomplish? And how have we interpreted the provisions at issue over time? I don't think, unfortunately, Professor, that it's right for me to get into specific cases and those that I think were rightly or wrongly decided just because of the judicial ethics that apply. But I do believe, as Justice Melody said earlier, there is nothing more important than what our court is doing right now. Our rights are uniquely powerful, and we can make them work for all Washingtonians.
Thank you. And Judge Larson, to you, please.
The advantage of going second is the first person kind of does a good job of answering the questions. So you don't have to say as much. But really what it comes down to is our state constitution, in a lot of ways, gives us more rights than the federal constitution. And if the Supreme Court is deciding a case based on our state constitution, the United States Supreme Court doesn't review those issues. And so if something provides greater rights than the federal constitution, our state Supreme Court is the court of last resort. If it provides less rights, if that's the argument, then the U.S. Supreme Court has a say. So I think it was alluded to earlier that the idea is to look at state law first. And because we have such a great state constitution, look at that first. The other thing, obvious difference is we elect judges. We don't appoint them like at the federal level. So those affect some nuances of how things are decided, but they shouldn't. The fact that we're elected shouldn't make any difference, but that is one of the distinctions between the federal court, the federal U.S. Supreme Court, and the state's Supreme Court. So ultimately, it comes down to whenever our Supreme Court can, if the state constitution answers the question, that's probably where the answer needs to be.
Thank you. And Judge Amamilo, the final candidate for position 5. And sorry, before I turn it over to you, all candidates should feel free at any point to ask me to restate the question. We don't have chat enabled, so I can't paste the question in. And so please just let me know if you'd like me to restate the question.
No, I think I understand the question, and I agree with both of my peers regarding the differences that have been articulated so far. So I'm going to focus on how things are applied when the Constitution is particularly addressed at the national level, at the U.S. Supreme Court. I think most here, in terms of the candidates, are aware of the developments that we've been seeing across Washington state in juvenile law. And a lot of that has recently come from a case entitled Miller versus Alabama, where the impulsivity of youth was addressed at the national level, and what followed was a slew of cases across the nation where state courts had to look at how we were treating youth across this nation. And Washington state has codified the impulsivity of youth in understanding that we have to look at when we're sentencing a youth. We have to look at the age and stage of their development at the time when they are being sentenced for very heinous crimes that they would otherwise be treated as adults. And as you all are aware, there's been multiple changes to the sentencing guidelines for juveniles, and we have JR to 25 now because there has been a huge impact from the interpretation of how youth should be treated under the Constitution and in juvenile law at the national level, and then that has been now codified in Washington law. And I presided over a number of those cases where juveniles that were sentenced to 30, 40, 50 years in prison had to be resentenced because of the change in the law at that level. So that's an example. My colleagues have already identified the major differences, and I would have started with Washington state's Constitution provides more protections than a federal Constitution.
Thank you, Judge Amamilo. We'll move now to position 4, and then to 3, and then to 1. So for position 4, we'll begin with Judge O'Donnell and then Judge Burke, please.
All right, thank you. You got a nice primer from my colleagues, but there are a couple of other differences I'll just touch on. The first is the justices of the Washington State Supreme Court have to comply with canons of ethics, and the United States Supreme Court justices amazingly do not. We have canons that we have to conduct ourselves ethically in how we do business in Washington State, and that's a huge plus. Uh, the other difference in terms of our Constitution and the focus, you've heard some of them, but one worth mentioning is that education and the funding of education is a paramount duty in Washington State. That's not in the federal Constitution. And you've seen that play out and have intersection with our state Supreme Court in a case known as the McCleary decision. And that was a very involved process that the Washington State Supreme Court engaged in, ensuring public education was fully funded. You heard about elections, and we're now in the season where elections, and especially elections for this court, really matter. Just to give you folks some comparison, in the trial court level where I am, I started as a judge 13 years ago, and between when I started and now, nearly 80% of the judges on the trial courts in Washington State have been appointed. So these elections really matter, and your choice is going to matter in who serves on this court. And then the last thought I had for you, and I've got to make sure I read my writing here, is we age out. Unlike justices on the United States Supreme Court, at the age of 75, you got to hang up your cleats. So those are some differences between our system and the federal system. All good, in my view. Thanks for the question.
Thank you. We'll move to Judge Burke now.
Yeah, that's a great question. I think that the state appellate judiciary has a special responsibility to safeguard the provisions of the Washington State Constitution. It's probably our number one job. As has been mentioned, there are a lot of differences, and they stem from the fundamental fundamental plan of American federalism. The federal government is a government of limited powers, and so the federal Constitution gives limited, minimal baseline guarantees. But the states actually have to make a society of work. Our Constitution in Washington is the product of the beginnings of the progressive era. It was intended as a progressive document when it was fashioned on provisions from the Oregon and earlier Indiana constitutions. Justice Angela started with some of my favorite provisions of the Washington Constitution. I'll add a couple more. Article 1, Section 12 prohibits special interest legislation in Washington, no special perks in our state. We have a provision against two subjects in bills, so legislators can't log roll unpopular things along with popular things. I'm going to go ahead and mention, though, one state Supreme Court decision that I agree with pretty much, and that's State versus Gunwale. And in Gunwale, the Washington Supreme Court said that as we interpret these unique provisions of the Washington Constitution and the rights they afford everyone, all of which have been mentioned, we have to do so carefully, thoughtfully, based on reasoned analysis, so these rights serve the purposes that they were intended to serve. That's an important question. Our protections, as a matter of state constitutional law, have never mattered more than they do now. And as a justice, I will ensure that they are protected carefully and thoughtfully. Thanks very much.
Thank you, Judge Burke. And now moving to position 3. First Judge Hawk and then Judge Diaz, please.
Thank you, Professor. So I don't have a lot more to add to the great explanations that my colleagues have provided, but most people don't understand that the Washington Supreme Court generally interprets Washington law and is the court of last resort on many important state law issues. Obviously, the federal Constitution is the supreme law of the land, but our state constitution, as we've been discussing, can and often does provide greater rights because of different language in our state constitution. So one area of law that I practiced as a public defender that comes to mind is Article 1, Section 7. That's an area where in Washington, we have greater rights and protections for individuals. So search and seizure is that context in the criminal law setting. So our Washington Constitution, all the provisions of the Constitution are equally important, but there are some provisions that, as discussed, have different language than the federal Constitution and provide a degree of greater rights, as explained. But it's important that we give meaning to all provisions of our Constitution accordingly. And one example too is in where our state constitution goes further than the federal Constitution in terms of rights is privacy and education. And it's because our state constitution is written and interpreted to put individual rights first. Thank you for the question.
Thank you very much. And Judge Diaz, please.
I thank you also for the question. I teach a course. I'm actually sitting in Seattle University Law School right now because I just finished our last class on a course called Washington Constitutional Law. It's a class I teach with Judge Feldman. We start with gun wall, which is, as Judge Burke mentioned, a framework for analyzing when we apply state constitutional law, when we apply federal constitutional law. And then we march through the really impactful decisions that our state Supreme Court has made over the last 20, 30 years, starting, both criminal and civil, with Monday and the Gregory case, Gregory being the death penalty case, and civil cases, McCleary, which was mentioned by Judge O'Donnell. And another example on the civil side is Martinez-Cuevas, which is a labor case where the prevailing wage law was found to be apply because our state constitution protects it. Really just impactful cases. But more importantly than that, I think, is that on the Court of Appeals, we actually do these analysis. We then go with our judges on the panel and engage in group decision making to see, when federal law applies, when constitutional applies, and what the state constitution, what our state Supreme Court has been saying, sometimes for decades, about our state constitution. And then we write it up. And I've written, like I mentioned, over 200 opinions. So you can see the tools, the principles of statutory construction, the principles of constitutional construction, how we apply those principles to actual cases. And then finally, I think it is important to mention also, and I agree with Judge Hawk on this, that one of the more interesting differences is Article 1, Section 7 versus the Fourth Amendment, and there where we're protecting the private affairs of people. And that really goes to our history. We are more protective of rights here, and I commit to continue that history of protecting individual rights consistent with the founding of our state. Thank you.
Thank you, Judge Diaz. And finally, let's move to Justice Melody and then Mr. Edwards for position one.
Sure. So you've heard a lot about the differences between the two constitutions, and part of that is just the difference in time. So the Washington Constitution comes at 1889. It's a full century after the federal one, and it's different in so many of the ways that you've already heard about. I'll sort of add one more, which is Article 1, the very first section, which says that all political power is inherent in the people, and governments derive their power from the consent of the governed and are established to protect and maintain individual rights. And there's just nothing like that in the federal Constitution. And I think that tells you sort of the moment that our framers were in. And you see that, all the way through all of these provisions that you've heard about that are sort of broader and more protective than the rights that we enjoy under the federal Constitution. In terms of the work of the court, it's happening all the time. So I was just looking over our winter docket, the arguments that we've just completed hearing arguments on, and there are cases about your rights if you are a criminal defendant and the police have destroyed evidence that might be able to prove your innocence or at least lessen your culpability. What are your rights in that circumstance? There are two cases about what happens when racial bias infects or is alleged to affect trial, either because there is racial bias on the part of a juror or by a prosecutor who is like one of the lawyers who's making arguments. And then, separate from the constitutional work, as I kind of said up top, state law is really where the action is at for almost every kind of law that impacts our everyday lives. So whether it comes from the Constitution or our statutes, it is state law that sets almost all of the criminal law, governs our family law and our relationships when we need parenting plans or other things, sets workers' rights, housing rights, property rights and your small claims rights. And so state law is really, really key, and interpreting it separately is really important.
Thank you. And last but not least, Mr. Edwards, please. You are muted, Mr. Edwards.
Can you hear me now?
Yes.
Okay. Thank you. As you've heard from the other candidates, there are both similarities and differences between the federal Constitution and the state Constitution. Both constitutions are based on concern for limited government power. In Washington, there is very much a focus on power being in the hands of the people rather than in the hands of the government. There's been a lot of talk about the additional protections that the Washington Constitution provides, but the Washington Constitution is also easier to amend than the federal Constitution. While the federal Constitution has been around for over a century longer, there are only 27 amendments to the federal Constitution. The Washington Constitution has been amended more than 100 times. And all of those amendments were made by the people. And then finally, another significant difference between the state and federal constitutional structure. At the federal level, judges are appointed. In Washington, they are elected. And while two of the candidates you're hearing from tonight were recently appointed by the governor, because the framers of our state constitution desired to assure that judges are elected by the people rather than appointed, when the governor appoints a judge to fill a vacant position, the appointee does not serve the remainder of the term they were appointed to, but must stand for election at the next general election. And that power to the people to have your judges elected by the people is a significant power under the state constitution.
Thank you. So we will move on now to our second question. This one concerns the role of precedent and the state Supreme Court's role in determining when and whether decisions need to be reconsidered and overturned. For people who have perhaps watched confirmation hearings of the United States Supreme Court justices, the term is stare decisis. So one of the defining responsibilities, as I mentioned, of a Supreme Court justice, of a state Supreme Court justice, is deciding when to follow its own precedent and when to reconsider it. So each candidate will have 2 minutes to respond to this question, please. The legal standard that we have in Washington is that the state Supreme Court may overturn its own prior decisions if those decisions are both incorrect and harmful. As a jurist, how do you or would you gauge what is incorrect and what is harmful? Again, you'll have 2 minutes, please, and we will start this time with position 3, Judge Diaz first, and then Judge Hawk. Thank you.
Thanks. I don't know that we're going to be able to cover this in a rigorous way in 2 minutes, but I will do my best, Professor Levin. You are correct. I sometimes think of it as wrong and harmful, but incorrect and harmful is right. I'll tell you that precedent is extremely important. Precedent is what lawyers rely on when they are advising clients. It's what governments rely on when they're drafting policy. It's what all levels of judges, including our state Supreme Court, look to when they're deciding cases. We have to be extremely respectful. It creates stability, predictability, and as I was a practicing lawyer, actually litigating both criminal and civil cases for 16 years, the idea that I couldn't rely on precedent in some fundamental way would have undermined my ability to advise my individual clients, my governmental clients, and then ultimately the United States as my client. That said, the law is not calcified. Cases say that over and over again. And I believe in a judicial philosophy called American pragmatism. It is a philosophy that is based on the philosophy of William James, who's a philosopher from the East Coast, that really views the law as something that is stable but also flexible and grows as things progress, as issues that we couldn't anticipate under the law arise. And so having a wrong and harmful standard is not a bad standard. And the Supreme Court has given us a lot of guidance on how to apply it. And I would look to that guidance as well. And in fact, when I might be the only candidate, I'm not sure about that, maybe not, but I pro tem'd on the Supreme Court a couple years ago. I got to handle 3 important cases there, dealing with precedent and other principles of statutory and constitutional construction. And I would apply that same experience if I got elected to this position. Thank you.
Thank you. And Judge Hack, please.
Thank you for that question. So, in terms of the standard of incorrect and harmful, one thing that comes to mind after George Floyd's death in 2020, our Supreme Court drafted an important letter to the legal profession about the how the courts have been complicit in anti-Black racism throughout our history. And they took very critical and important leadership steps to target specific cases that have resulted in a harmful and particularly racist outcome and result. And they took steps to overturn those cases. And that's, a very helpful examples in recent years where our justices have provided that leadership in targeting those particular cases resulting in harmful impacts. But it's important. As a judge, I think that it's obviously decisions are dictated by the facts and law of each case. And an appellate ruling should seek to avoid, absurd results that might cause harm. And again, as the standard that you've pointed out in terms of incorrect and harmful, precedent should be upheld and not quickly changed unless it is clearly wrong and causing harm or resulting, as I mentioned, an example that most frequently comes to mind is a particularly harmful or racist outcome. Thank you.
Thank you. We'll move now to position 5, beginning with Judge Amamilo and then moving to Justice Angelo and Judge Larson.
Thank you. And thank you for the question. I think this question really assists all of us in knowing why being a trauma-informed bench is critical as we look at the law and how the law has had unintended consequences. We've seen our Supreme Court address issues related to land use and treaties with the sovereign nations, Native American nations here in our state. We've also seen the Supreme Court deal with terminations of parental rights and improvements in child welfare law, and some of the ways it have been applied to the Native American and marginalized communities. So incorrect and wrong and harmful are very high bars, but they need to be a high bar because trust in the law, public trust in the law, depends on people knowing that the law is applied consistently and fairly. And if, for the most part, the law is applied consistently and fairly, you don't have outrage. But once you are required to address something that should shock the conscience, and you can no longer look away when you have an unintended consequence that everybody agrees is horrific, I think that's why the bar is that high. Otherwise, I would support precedent. I believe that a trauma-informed approach, though, supports that trust while maintaining fidelity to the law, and judicial independence is essential. We individually look at each case as a independent Supreme Court justice and then come together with our colleagues to talk about what the issues in a case are, but we bring our lived experiences. As a trial court judge, I've seen every lived experience that people can face. I've also been a public defender in my career, and then my time in the military from enlisted to senior warrant officer. I've just seen a lot and also been deployed. So I've seen a lot of harm that can come from just living. And when the law is applied appropriately, then for the most part, the law as written works for everybody. But once you get to a point where you have to address and you can't look away from harm or wrong, then there is a process that we have to go through, and I believe it's a very rigorous and robust process. And I think it would demonstrate to the people of Washington that I, being a part of that process as a new Supreme Court justice, will bring to that robust conversation a real measured approach to the question of, do we break with precedent? Because that then ripples across the entire state, and it's a very serious and provocative endeavor. So thank you.
Thank you. Thank you. And moving to Justice Angeles, please.
Thank you. So just a few things that I think haven't been said yet that are really important. One of them is overturning precedent really does strike at the court's legitimacy in some fundamental cases. So I have to confess that the Dobbs case from the U.S. Supreme Court overturning reproductive rights really helped to change my thinking about the prong of the test where we ask ourselves whether a case was incorrect. And there are lots of things in federal law that we look to know whether something is incorrect. Have the other cases cited by that case been undermined? Have there been a lot of scholarly criticisms of the case? These are things we look at. But if the answer really does seem to be that this case needs to be re-examined because there are different people on the court than there were when the case was decided, that really does strike at the heart of predictability and consistency in a way that undermines respect for the judiciary, and I think contributes to some of the reason we're seeing a lot of people upset, unhappy, and generally not respectful of our courts. So to borrow a phrase from the Declaration of Independence, we should not revisit precedent for light and transient reasons. This is a very serious issue when a party invites us to depart from prior precedent and to overrule the cases that our court has issued. So I think everyone here on this call understands that this is a significant issue for our court. It is one that our court takes seriously, but it is one that we continue to have to look to with great gravity and humility as we look at our precedent.
Thank you. Judge Larson, please.
On that last note, sometimes the courts are asked to do too much when it comes to public policy. In Washington State, for instance, reproductive rights were established 4 years before Roe versus Wade by popular vote, referendum 20 in 1970. So the courts didn't decide that in Washington. It's done by popular vote before Roe versus Wade, and it's unaffected by Dobbs. Maybe even strengthened by Dobbs because Dobbs said a state right. And it's adopted by statute, not the courts here. But precedent is extremely important. That's why it's important when we're electing judges that we elect judges that aren't motivated by politics or personal opinion. Because precedent is something that the test for a judge is not what our personal opinion is, it's our ability to overcome it. Because precedent is so important to follow in the sense of providing that stability. And the incorrect and harmful needs to be an objective standard. It can't be based on what I personally think. It has to be based on something that's objective. And when you ultimately decide that case, the public trust and confidence that comes from that case has political ramifications, just like the Dobbs case, other case that ends up affecting the political body. And that's why we need to make our other branches of government work the politics and have the courts not be so involved in those. When it comes to McCleary, just for the listener's note, I was vice president of the Federal Way School Board when I conceptualized Federal Way's fair funding lawsuit. There's an op-ed in the Seattle Times, September 8, 2006, where I actually was the catalyst that ultimately led to McCleary. And our lawsuit was a little different than McCleary in the sense that we were challenging the equity in terms of distribution of money. And the Supreme Court reversed our trial court. We had a 10-year fix in place. And I said when I ran in 2016, I said it's going to only take 10 years to get back to where we were. And I was wrong. It only took 3 because we didn't fix the way we distribute money. But precedent decided McCleary because there was a case from the 1970s that declared the basic education case that ultimately declared kind of the standard that was used in McCleary. But ultimately, precedent is important. But I think we need to do a better job in the courts to insist that the other branches of government do their job better. So we're not saddled with have politics foisted on the courts, which then decreases confidence both at the state and the federal level. People lack confidence. Some people lack confidence in the federal. Some people lack confidence in the state. To an extent, they're both right. But a lot of it's foisted on us. because the other two branches of government aren't doing their jobs. And we need
Thank you, Judge Larson.
Thank you.
And moving on to position 1, Mr. Edwards first, followed by Justice Melody, please.
Yes. So as we've heard, precedent is extremely important in our judicial system. Stability and predictability govern every aspect of our lives. We want to wake up in the morning and know how things are going to operate and what the rules are that we have to live by. If the rules change because the members of the court change, it significantly undermines trust in the courts and the judicial system. That's true at both the federal level and at the state level. So the question was, how do we determine when a decision was incorrect, when a decision was harmful? The two criteria in Washington for applying or for moving away from stare decisis and overruling precedent rather than following it. And I think what you've been hearing is a question of whether it was wrongly decided. I don't know that we heard much about how judges would make the determination about when a prior decision was wrongly decided. For me, that criteria is whether the decision that's being revisited was issued contrary to the statute or constitutional provisions at issue in that decision. With respect to harmful, that's going to be determined based on the facts that are submitted to the court as to make that decision. It's going to be necessary to show evidence of harm created by the decision in the record before the court, not the judge's own perception of harm that may have resulted from that prior decision. So on the bench, I would apply my independent consideration of the arguments presented with respect to the statute and the constitutional positions and the evidence presented. Thank you.
Thank you. Justice Melody, please.
Thanks. So you've heard from everyone that respect for precedent is so important, because that's the consistency, the stability, the predictability that we all want when we're running our lives, right? Whether we're running our families or our businesses, as workers, as tenants, whatever it is, we want to understand what the law is so that we can follow it. And there's a component of judicial humility that's involved in respect for precedent, because it shows that we understand that stability matters, even if it's not a rule that we would have written in the first place or even agree with. That's how it works. And everybody who's a judge on this call took an oath to uphold the law, whether or not they sort of personally agree with it. So that's the foundation. And we also owe humility to say when we've gotten it wrong. And so, part of the judicial role is to correct mistakes. And when there's been a showing of both incorrectness and harm, part of the job is to correct that mistake. And I'll tell you a story. So there's a case that the Washington Supreme Court reversed, right, overruled. And it was a case involving parents whose 3-year-old had died. And they were a Black family, and they wanted to bury their son at a cemetery that was specific to children. It was a specific cemetery for young children. And the cemetery refused to let them bury their child there. It was 1957, and the cemetery was segregated. And the Washington Supreme Court upheld that decision, relying on the doctrine of sort of separate but equal. They could get cemetery services at a different cemetery. And in 2020, the Washington Supreme Court overruled that precedent, holding that it's incorrect and harmful and devaluing of the lives of all of us when we apply a separate but equal framework. And I think that's just an example of sort of a case where, where doing the right thing requires overruling a precedent, even though that should be and is very rare.
Thank you. And then let's move to our final candidates on this question and for position 4, starting with Judge Burke and then closing with Judge O'Donnell.
Yeah, as everyone has kind of mentioned, we're balancing stability and predictability on the one hand versus justice and sometimes truth to real world facts today on the other hand. And I may be the only person here for whom this is not a theoretical question, As an appellate judge, I have written appellate decisions that have overturned past decisions of the Court of Appeals. And it's not something we do lightly. We recognize that every time we do it, we risk undermining our independence and appearance of impartiality and public confidence. And it's really important because we only have the power of our words, but it makes a vital point about the nature of what we do. The big distinction between an appellate court and a trial court is we literally can't make a decision without explaining our work. Our job is to not only decide if on appeal if the case is going to be affirmed or reversed, our job is to explain the reasons why. And we frankly spend more time talking about the reasons why than anything else. And, we call it an opinion, but it's not my opinion. It's the group's decision of our best view of what Washington law is. And the law belongs to the people. So what we're really doing is we're analyzing the reasons that were given before, and we're asking if they still work today. And if they don't, we have to confront with honesty the possibility that we need to revisit that precedent.
Thank you, Judge Burke. And Judge O'Donnell, please.
Thank you. Well, my colleagues have captured most of these issues, but I guess I would use this analogy. The judiciary of the three branches of government is sort of the tortoise, slow and wise. And overturning precedent is something that we have to do very carefully, and you've articulated the standard. I think the best example that I could give folks, the most real example, is juvenile justice. My colleague, Judge Emamillo, mentioned the Miller case, which started a series of cases in the federal level and then to the state level, where the courts recognized, because science told us juveniles are different. And so when there would be sentences for juveniles, life without the possibility of parole, the recognition there that was clearly wrong and clearly harmful. I'll give you an example. When I started as a prosecutor, I could do 5 trials in a week, and there were 15 of us up there doing juvenile cases. That was 25 years ago. Today in King County, I think they might have tried less than 10 cases in the whole year in juvenile court in King County. And the reason is we've recognized you got to treat kids differently. So that's a good example of clearly wrong, clearly harmful, and the court going back and saying, we need a redo here. We need to rethink this. The science caught up, and we could see that our youth were not being served by that system. So thanks for the question, and I'm going to cede back 30 seconds of my time.
Thank you. Thanks to every candidate for their responses to that question. We're going to move into our third segment, and this one is going to have a different pace and structure. This is where I'm going to ask different questions by position or judicial race. So there will be 4 total questions in this segment. And the reason for doing this is to educate voters about the work of the Supreme Court besides deciding cases. So the Supreme Court also is involved in significant administrative work, including exercising its rulemaking authority and overseeing various commissions and committees. So I've constructed this segment to really give voters a richer sense of the other work that Supreme Court justices are doing besides judging. So I'd like each candidate to respond to the following question, again, with 2 minutes, but again, just this question as to the first position. So position 1, this is the question for both candidates. And it has to do with voter participation in judicial elections. So what, if anything, should be done to improve voter participation and engagement in judicial elections? And what role, if any, should judicial candidates or justices, current sitting justices, itself play in that effort? So let's start, with Justice Melody on this one, and then we'll go to Mr. Edwards.
So
my apologies for failing to signal the order there.
No, I love this question. It's so important. And because the elections this year are going to be in a year where there are not other statewide elections on the ballot, no senators, no attorney general, no governor, right? And so it's really our job to get the message out as the statewide election that's going to be happening about the role of state courts. And what can we be doing? Well, we can get outside of the Temple of Justice, which is something that I do a lot of as a sitting justice. In the last 2 weeks, I've been to Mount Vernon, Wenatchee, Spokane, and Walla Walla to talk to people, including students, Rotary clubs and different civic groups about kind of the importance of these elections. We can keep asking and hopefully get some funding for the Secretary of State and for the voters pamphlet to include judicial races in the primary, which they currently don't. And we can, make sure that we are doing our work. Law Day is coming up on May 1st. It's a celebration of sort of Constitution, rule of law. And we're running through the WSBA a program called Judges and Lawyers in the Classroom. And I'll be there. I hope my colleagues on this call will be too, because it's an opportunity to just be talking with students who are, oftentimes in high school. They're our next generation of voters. Some of them are voters now. They're 18 years old in high school. And so I think all of those things are opportunities. It's about half the job is what I'll tell you. Half the job is working on kind of rule-based judicial branch administration, access to justice, and other kinds of things that are not doing the cases, to put it in the way that that you did, Professor Levin. And so it's a full half the job, and you have to be working at it all the time in addition to doing your careful casework. And I think the best way to represent and serve 39 counties is to get out to 39 counties. And so that's one of the reasons why I'm on the road a lot.
Thank you, Justice Melody. And the same question to you, Mr. Edwards.
Yes, can you please repeat the question?
Of course, yes.
Yeah.
So the question is, what, if anything, should be done to improve voter participation and engagement in judicial elections? And what role, if any, should candidates or justices themselves play in that effort?
Yeah, well, I want to start by distinguishing those two different things. What are good actions for to be done generally to improve voter participation? I think we all would agree that in a democracy where we have elections, it's important that everybody get out to the polls and exercise their most important rights of voting for their elected officials. As far as what role is it for a sitting Supreme Court justice to or the court as a whole to improve voter participation, I don't think that in our system of separation of powers that getting out the vote is a function of the Supreme Court itself. When individual candidates, including current justices, are traveling around to campaign for their own election, I think we need to recognize that is, while it's certainly part of the democratic process and it's appropriate, it's not in the role as a Supreme Court justice, but in the role as a candidate for becoming a Supreme Court justice or remaining the seat. So I think that the court's role in getting out the vote and voter participation is none. Every citizen in Washington's role in the campaign is critically important. Everybody in Washington should get to the polls and vote for the candidates that they want to support, who will represent them in every position that is on the ballot. Thank you.
Thank you. So we're going to move to the next question. This is for candidates for position 3, so Judge Hawk and Judge Diaz. The question is this: the court recently changed the standards for public defenders to reduce the number of cases public defenders are allowed to carry. What are your thoughts about the reduction in caseload standards? In your response, please make sure to address your perspective more generally on public defense funding. And let's start with Judge Hawk, please.
Thank you for that question. So As I mentioned, I have served for many years as a public defender. So, but more of my experience as public defense was in the federal system, where we didn't have caseload standards. And here in Washington, our public defenders around the state work incredibly hard. They have very difficult and high caseloads, and it's really critical that these caseload standards have been adopted by our Supreme Court. There was a long comment period, and a lot of thought and consideration went into looking at data and studies nationally, really hearing on the ground from defenders in all of the counties around our state. And there's no one size fits all necessarily, but we unfortunately do have justice by geography at times in our state, and things look different based on where you are in the state. And not because, in part, at the state level, we spend such a low amount of resources funding public defense that in part results in some of those disparities. But I'm very proud of the leadership of our Supreme Court. I know the funding issues are difficult, and at the county level, state level, there's always a struggle about funding, and with so many other important priorities to take care of. But the constitutional right to counsel is absolutely critical in ensuring that there's fairness and justice in our system. And the caseload standards are a very important step in that direction to make sure that our defenders have the adequate time to put into each case, to make sure each individual accused of a crime is adequately and fairly represented. And so I support the court's decision and the work that has been done to modify and adjust the caseload standards. Thank you.
And Judge Diaz, please.
Yeah, this is a great question again, Professor Levin. I'll say a couple things. First, that I've had some experience in analyzing and providing recommendations on caseload standards. When I was at the Justice Department, we at the U.S. Attorney's Office worked with the Access to Justice program, which is part of the DOJ, in filing a statement of interest in a lawsuit that had been filed up in Burlington and Mount Vernon against those cities for not providing adequate numbers of public defenders in their misdemeanor cases. I agree with Judge Hawk that it's a fundamental issue of fairness, and it is a constitutional right to have not just a warm body that you may or may not see before you walk into court, but an effective advocate for you. And our state and our state Supreme Court is right to take up the issue because there's a real crisis in our state on this issue. I think it's going to be a more complicated issue than yes or no. I support or don't support this. I think it's going to be a conversation with the legislature. I think it's going to be a conversation with individual municipalities. I think it's going to be there's a long-term implementation already, but there's going to be a long-term conversation about how to make that real. As I mentioned before, I teach Washington constitutional law, and the McCleary decision was a good one. And I see my friend and the amazing lawyer, Tom Ahern, on the call too, and he came on and explained how McCleary was a multi-year effort in getting that education decision implemented. I have experience in that. When I was on the Seattle Police Consent Decree, I worked on that case implementation for 8 years before we reached full and effective compliance. And in terms of, again, this is a balance that Supreme Court justices just have to have. I mean, the day job is getting to the record and resolving disputes, but this is a big part of the job as well, which is balancing all these other administrative duties. And I also have experience on that. I chair the Interpreter and Language Access Commission. I'm on the Commission for Judicial Conduct. I know how to reach that balance and really dig in an issue when it's important and appropriate, which this one is important to dig into. So thank you for the question.
Thank you, Judge Diaz. So we'll move to the next question. This question is for the candidates for position 4. The Supreme Court oversees, as you actually just heard Judge Diaz mention, the Supreme Court oversees a number of commissions and committees, including the Minority and Justice Commission, the Gender and Justice Commission, the Commission on Justice Efficiency and Accountability, the Washington State Jury Commission, the Commission on Children in Foster Care, as well as many other administrative committees that I don't have time to list at the moment. But the question to the two candidates are, which commission or committee would you want to serve on and why? And let's start with Judge O'Donnell, please.
Well, thanks for the question. I'd want to serve on the Rules Committee as a start. And you're right, there are a lot of commissions and committees, but I would volunteer for the Rules Committee, and I would volunteer for one other. We currently have a AI-focused committee that the Chief Justice started. I'm currently on it, and I would want to continue that work because it's going to be so important for the judiciary going forward. And let me say why rules. You heard a little bit about the public defense caseload standard. I have a little different take. Not that the caseloads shouldn't have been reduced, but my criticism was reduced really without a plan. And those impacts are going to be felt most acutely over here in rural counties. Yakima, Benton, Franklin counties, in some respects, already have, even before they've gone into effect. So the rulemaking process, I think, needs to open up. It needs to be more transparent. There needs to be more participation in rulemaking because rulemaking is so consequential in how justice is delivered in the state. So if I'm lucky enough to get elected, that's where I'll volunteer. The other one has to do with what are we doing with this technology, AI, and how is it going to impact the judiciary? How is it going to impact the practice of law? I've said this in other settings, but we have to really be careful that AI justice isn't a thing here in Washington State, meaning that AI ever substitutes for human decision making. Because if you do that, then it's garbage justice. And you should never have AI decide when a parent should spend time with their kid. So I would be really motivated to be involved in that. I've been involved with the State Bar Association's AI task force, help draft principles for the bench, or for the bar. This is coming at us. We think right now that we know how this is all going to develop. It is going to change in so many different ways. So those are the two areas that I'd like to be involved in. Thanks for your question.
Thank you. And same question to Judge Burke, please.
Yeah, I'm going to go ahead and echo a shout out for the Rules Committee because I think that the rules of practice and procedure, in my experience as a lawyer for 20 years, have a huge influence on whether people can actually enforce meaningful rights in court. And I think the way that those rules get written is of vital importance. I would actually like to see kind of perhaps a slight revision to the way we do the rules. I think it ought to be a little bit more like we write pattern jury instructions, where we get the critical stakeholders in the room, and typically, and I'm just going to nerd out for a second here, that they're the nerdiest people from their practice specialties who are going to be the best at figuring out the really best way to write a rule. And I think that's a good model for rulemaking that brings in all the stakeholders who are affected by the rules, including perhaps the stakeholders who historically might not have been consulted. Which brings me to my next comment about the Minority and Justice Commission and the Gender and Justice Commission. A lot of other states actually name those commissions after pioneers in their field. One thinks of Justice C.Z. Smith, and one thinks of Justice Dimmock, who recently passed away, but I pass over that for a second. The important thing about those commissions is they bring really everybody to the table, including people who maybe weren't consulted when we first wrote all the rules we have. And it would be consistent with one task force I want to stay on, which is I'm on the task force to write workplace harassment training standards for workplace harassment by judicial officers, which we need to get on top of and make sure is not a thing affecting our dedicated court staff across Washington. So that's a great question.
Thank you, Judge Burke. So we'll move on to the final question in this segment for candidates for position 5. This one is going to take me just another second to sort of provide the context for, so thank you for bearing with me. Audio fine? I think let's see, everybody can make sure to mute. Excellent. Okay. As a sitting justice, you would be tasked with deciding on new court rules, as you've just heard about from the previous respondents, in an administrative capacity. So this means you are permitted to discuss them and share whether you would or would not support a particular rule, again, when the court is sitting in that administrative capacity doing rulemaking. There is currently a proposal to amend Criminal Rule 3.2 regarding bail standards, make the requirements for imposing bail stricter. What do you think of the new bail rule, or where are you with respect to what is being proposed? And what are your thoughts on the court's rulemaking authority more generally? Should you have time to address both? And we will start with Judge Larson, please.
Thank you. This is a very important rule that they're considering, and it's very important because I think what we're doing is taking the wrong approach. What I did in my court, our court was the first court to embed peer navigators, to start with therapeutics, to make the court more about problem solving than about punishment. And what happened is our failure to appear rate went way down. And that's why I'm an advocate for switching the way we do criminal justice to start with therapeutics and then turn to punitive, because it's worked so well. I had a domestic violence calendar before I retired. I had 45 people on it. We had like 3 or 4 failures to appear. So warrants are a function of people not coming to court. And the question is, talk about trauma-informed and everything else. What do the courts project to people that intimidate people, perhaps not to show up? The other thing is just very minor technology things we can do when it comes to texting and everything else. And to remind people of court dates, that's another thing that's been done in several trial courts that's had a great effect. So what we're doing is we're looking at this backwards when we're talking about managing a rule to make it more difficult for a judge in a court to deal with people that aren't showing up. That's not the answer. The answer is to make courts institutionalized through court rule. Keep in mind, there's an RCW 2.04.200, that if a court rule exists involving procedure, it overrides a state statute. So we have a lot of power in the courts, for instance, to institutionalize therapeutic approaches, institutionalize those kind of things that would answer some of that question, make courts more useful to people. And that the idea of running a repair shop, not a junkyard, that's a switch of attitude, and that's free. That doesn't cost us anything. And the Supreme Court, it being a trial court judge for 18 years, immigrating into the criminal justice system, again, I like them all. I'm not personal criticism. It hasn't been a priority. When it comes to commissions, there needs to be a behavioral health and justice commission. That's one that doesn't exist. By the way, I've actually written a statute. Anybody's interested on creating the Judicial Elections Commission that would do exactly what we talked about earlier. I've written a paper on public defense, how to actually solve that problem, which requires the state to partner. And those things are something. And I agree with the comment earlier. The Supreme Court, when they adopted that rule, they kind of hit and run. They didn't become part of the solution. And it is a thorny issue in our communities, both monetarily and otherwise. And like our public defense firm that was doing our work, I think they have just under 20 lawyers. They're going to have to go to 40 lawyers, they predicted, which that has to be paid somewhere. And so there has to be solutions. And what I've actually proposed is something that would be a very sustainable solution, encouraging public defense districts and everything else. So, and that wasn't part of my question. But anyway, I thought I'd throw that in there.
Thank you. Thank you. And let's move on to Judge Amamilo, please.
Thank you. Thank you for the question. As it relates to Criminal Rule 3.2, I have a lot of experience, not only as a litigator, but also as a judicial officer presiding over pretrial first appearances. And what I would say is, as it relates to a rule that seeks to impose stricter requirements on bail, take away the judge's ability to assess the situation before them. Pretrial release conditions, we talk about bail, but it's just one tool of pretrial release conditions. And the whole point of pretrial release conditions is to compel people to comply with pretrial release conditions while they are proceeding through the process. And we have 2 primary parameters, that is risk to community safety and risk for failure to appear. And Thurston County and other counties and other jurisdictions, we have risk assessments. There's a pretrial risk assessment that we use. We talk about the level. It produces a score that allows us as a tool to look at whether or not this person would be need to be a high risk supervision or low risk supervision. We look at some history. We connect these people to services, and we also use the system that I believe Judge Larson just mentioned, which is a reminder system to try and help people comply with conditions of release. That is the whole point. So my feelings about that are we fully using the Criminal Rule 3.2, which has a myriad of factors to look at as to what would be at stake for people to not comply with the pretrial release conditions? Like, would they lose their job, or would they lose their home? Would their family be disrupted? Would they go out and commit some crime that can't be where you can't adequately protect the victim? So we're looking at all of these things, and I think to rush right into let's make it stricter without looking at the basics of what are we here to do, compel them to comply pre-trial, and take an iterative approach to what you put in between to help them comply and have a reason to comply. And so that's my response to 3.2. I also wanted to say that I would like to be on the Commission on Children in Foster Care, having currently serving as the DCYF Judicial Officer on the DCYF Oversight Board, sentencing appointed to the Sentencing Guidelines Commission that I've been serving since 2022. I'm on the Alternatives to Incarceration Task Force for this court. And I'm also very data driven. And I love that the task force and commissions in Washington State now include research scientists that bring in the information so that we are less likely to make an error when we are making changes to sentences, and or when we're trying to figure out whether a sentencing alternative has been working and if we need to relook at what we're doing. And then finally, I'd like to say on public defender caseloads, I was on the youth caseload standards because children in foster care also receive representation under certain circumstances. I was a youth attorney, and I was also on the commission that developed the training required for attorneys that represent youth. And then as it relates to the judicial role.
I'm gonna no, that's fine. We're a minute over, so I want to make sure we're keeping on track. But thank you so much.
You're welcome. Thank you for the question and opportunity.
Thank you. And finally, Justice Angeles.
All right. Well, thank you for the question. I'm going to take the second part of your question first because I think it's really important, which is what do I think generally about the rules process? I will say this. I think all of you would be heartened by how deeply the court looks at the potential rule changes and how much effort it spends really analyzing and asking for input around the state in terms of changes. So the court is currently looking at some changes about the admissions to practice rules, how we decide which young lawyers, including those who may have a black mark on their past, may have had some difficulty with the law in the past, when should and under what circumstances should they be allowed to practice law in the state of Washington anyway. And the court has been just exhaustive in thinking about these issues, how to balance access to justice, how to balance giving people a second chance against protecting individuals in the state from lawyers who shouldn't be practicing. And that's the kind of insight, that's the kind of effort that A, the voters should be proud of, and B, I think should continue and will continue. There are times when rule changes come up to us that are not as clearly thought through. But for the most part, I've been deeply impressed with how seriously the court takes its rulemaking functionality. With respect to the bail rules, just two quick points that are critical. One is there is a constitutional right to bail, and there's a constitutional right to have bail set at the minimum necessary to ensure safety and to ensure appearance of the criminal defendant. And so that has to be our pole star. That has to be our guide star. People are innocent until proven guilty, and we have to protect our communities. But at the same time, so many individuals who can't afford justice and who are marginalized from marginalized communities end up spending a huge amount of time in jail. And so a rule change to ensure fairness and to try to protect the community while also allowing individuals to go about their lives is the right thing to do.
Thank you. Thank you to everyone for that lightning round with the 4 different questions for the 4 different positions. We are going to move into our final question of the evening before we move to short closings. So this next question is for all candidates, and it has to do with something that you've already heard mentioned by some of the candidates, and that has to do with the letter that the Washington Supreme Court issued in 2020. It was signed by all 9 justices, and it acknowledged the role that courts have played in devaluing Black lives and called for reflection and action within the legal system to address racism. I'd like each of you to engage directly with the commitment made in that letter. And so the specific question is, what is your perspective on the commitments made in that letter? And what, if anything, should it require of a justice in how they carry out their role? We will start with position 4, Judge O'Donnell, and then Judge Burke, and then we will move to positions 5, 3, and 1.
Yeah, thank you. And just to level set it for the audience, this came on the heels of George Floyd's murder in broad daylight on the streets of Minneapolis. And our Supreme Court basically had a call to the judiciary that we have to recognize what's occurred here, but also recognize our involvement in it as a system of justice. And so what can individual justices do? You know, there's a personal commitment to being educated of this history. That's really important. You have to understand, you have to appreciate what occurred and how it impacts how justice is delivered in Washington State. When this happened, I was a chair of one of the many committees that the Superior Court judges had, and this had to deal with legislation. And we took that letter, and as co-chair of that committee, we proposed that we were going to change on about how we look at every piece of legislation that the Superior Court judges would either support or oppose through a racial justice lens. That was important work, and it was a big change for us. Going forward, justices need to be devoted, committed to education and making sure that all judges in our justice system are aware of these systemic shortcomings. And we have to be proactive about it. We have to be mindful of it when these cases come up before us for resolution. If we don't have transparency and commitment to these issues, we lose credibility with the people we're supposed to serve. So I hope that answers the question, and thanks for asking it.
Thank you. And before we move to Judge Burke, I just wanted to highlight for our candidates and audiences, our attendees, we are moving to 90 seconds at this point, so you should see that updated clock on your screen. So Judge Burke, the question to you, please.
Last fall, I attended a week-long seminar about race in justice that was held in Montgomery, Alabama. The history, if you are a Black American or a Hispanic American or a Native American or a woman, at one time or another in this country, there has been legalized inequality under American law. At one time or another, you have been denied the supposedly constitutionally guaranteed basic right to due process before the deprivation of life, liberty, or property. I forgot Asian American. That was the one I stumbled on. And we have to be ready to hear that truth when it comes to us in individual cases, or we cannot do our job with honesty and justice today. My commitment is that I will listen for when that truth is real.
Thank you, Judge Burke. Let's move now to position 5, starting with Justice Angeles and then moving to Judge Amamilo and Judge Larson, please.
Thank you. So we have to ask ourselves, why is our justice system failing so many members of the Black community, of the Hispanic community in particular, the Latino community? And we have two commissions in particular that have done just an outstanding job identifying serious impediments to justice, the Gender and Justice Commission and the Minority and Justice Commission. And the Gender and Justice Commission's most recent report, it's 900 pages long, but it really grapples with the intersection between gender and race and how these issues are combining to make our courts fundamentally unfair for a lot of our population. But I want to highlight one issue where our court is really leading the way. So if we look at General Rule 37 and the objective observer standard that our court has enshrined, it is a way of ensuring that racial and other illegal bias is divorced from our justice system. And whenever it infects our system, even if it's implicit, even if it's subtle, that's a chance for our officers, our judicial officers, to re-examine what happened and to provide substantive relief. So we've done this in cases like Berhe and Henderson, even in a car accident case, even in a civil case. If there are coded racial messages, that is an unfair verdict, and it's something our courts have to make sure cannot stand. So this is a big issue. This is a long-standing issue, but the pioneers on the court have put us in the right direction.
Thank you. Judge Amamilo, please.
Thank you very much. When that letter came out, it was quite sombering, and it was quite affirming, considering I, as a judicial officer, came to the court during an election of a difficult year of 2020. So I was running a campaign when that occurred. And my conviction after the letter came in June of 2020 was that I had to keep going, right? I had to keep going. I had an obligation to keep going. I had to show up and be present and be in rooms where the experience that I have as an attorney can be leveraged along with my colleagues to help make sure that all insights are considered when we're making decisions. In Thurston County, we have a standing equity committee, and that equity committee, we actively took all of our rules, all of our protocols, our local rules, our systems and our protocols, and we looked at everything we were doing just to make sure that we were not having a blind eye or somehow not being aware of something that we were doing that would not show respect for every single person's basic right to be treated with dignity and respect. And I think that's the important thing here, is that when I'm elected to the Supreme Court, that voice, that perspective, that lifetime of living as an attorney, walking side by side with people for 18 years before I got on the bench, and actually listening to people who were being impacted by having an impact of that on them as they were experiencing it while I was on the campaign trail for the Superior Court. And people are still afraid now as I'm running for the Supreme Court, people are wondering, are we going to have the right eyes in the room overlooking the discussion, or being part of the discussion and contributing to the discussion in a collaborative way that keeps the urgency of the letter at the forefront of everything that we do, so that everyone is treated with dignity and respect. And as the military says, that no soldier is left behind, no citizen of Washington is left behind. Thank you.
Thank you. And Judge Larson, please.
Thank you. This is a great question. I think this is an opportunity to talk about what it looks like at the ground level. It's no secret I ran in 2020 and 2024. In the height of the George Floyd situation, I got an exceptionally well qualified from the Lauren Miller Bar Association, the Bar Association representing Black lawyers, because it's what we actually do. That dignity and respect piece. The justice system doesn't cause racism; it aggravates it. The way we treat people generally aggravates it and reinforces it. And so, taking that repair shop, not a junkyard, taking the people have potential, taking we're going to make your life better approach is the solution. The letter is something that I can't show that defendant letter saying, hey, it's all good now. You have to actually do stuff at the ground level. And we were doing it before the George Floyd incident. That's why I was able to get that rating. I got the same rating in 2024. GR 37 is a great rule, but only about 1% to 2% of cases actually go to trial. So what do we do with the other 98% that never see the inside of a courtroom? And in 18 years sitting on the bench, I had one Batson challenge the entire 18 years. So the bottom line is GR 37 is great, but to a person that's sitting in my court that feels like they're treated unfairly, what does that do for them, right? I introduced procedural justice into the Washington courts about 6 years ago. The other thing that is very important when it came to
And
jury
briefly,
service.
briefly, please.
Can I just sum it up?
Yep, briefly, please.
When it came to jury service, we were at the bottom end of people of color showing up for jury service. So I partnered with our diversity commission. We wrote 3 op-eds in the local paper, attended 2 cultural fairs 2 years in a row with the Minority and Justice Commission. When I left as a judge, there was at least 2, if not 3 or 4 people of color sitting on a jury of 6 in my court. Because of what we actually did, not just writing a letter, not just creating a rule, what you actually do.
Thank you. Let's move to position 3, Judge Diaz first, followed by Judge Hawk, please.
Great, thank you for the question. I think that the 2 questions were, what's my position on the letter, and what can a judge do about it? My position on the letter is very simple. It was totally appropriate. It was historically accurate. It is consistent with what our values are, and that's what it was. It was a statement of values. And what do litigants and what do judges do about it? Well, I think I heard that, yes, it came from in the midst of the George Floyd, but preceding that, there was Ferguson. And even before that, we had our own incident in Seattle. It was a killing by a Seattle police officer of John T. Williams in broad daylight, who was presenting no threat to the officer. And before this was an issue at the Justice Department, under the Obama Justice Department, we led and investigated, negotiated, and implemented a consent decree that reduced incidents like that, dropping unnecessary uses of force dramatically. I think what you have to do about it is you have to show up, as I heard someone else say, you have to listen, and you have to lead. And here, I believe I have led. As I mentioned, I chair the Interpreter and Language Access Commission, which ensures that people who are limited English proficients, in other words, not native English speakers, can access our courts as equally as anybody who happened to be born with English proficiency. I've also had cases. I've had these cases involving GR 37 repeatedly, and we want to ensure we don't backslide from the intent of that letter. And we also need to do that with someone who knows how to actually do these types of cases. So as a judge, I'll continue to do those things, and it would be an honor to continue to that tradition of ensuring that our courts are open to everybody, regardless of your race, ethnicity, national origin, or gender, or economic circumstances. So thank you.
Thank you, Judge Diaz. Judge Hawk, please.
Thank you, Professor Levin, for this question. As you might recall, I mentioned this letter in one of my earlier comments, just as an example of the leadership of our Washington Supreme Court and the commitment to tackling racial disparity and disproportionality that we know is widespread throughout our court system. At the time this letter came or was presented to judges and the legal profession in Washington, I was working at the ACLU of Washington and helping lead our work to tackle mass incarceration and racial disparity and disproportionality in the courts. And Professor, as you know, we also around this time, in response to the letter, we started the Race and Criminal Justice Task Force 2.0 as a call to action to mobilize judges and lawyers to really think about concrete recommendations and solutions to tackle the racial disparity and to collect the data so we continue to be informed and look at the issues of race and disproportionality and how that's showing up throughout our legal system. As a judge, I continue to serve with the Supreme Court Minority and Justice Commission. I'm active on our Rules and Legislation Committee, continuing to look at apply a race equity lens and look at racial disparity and disproportionality in all the ways that we can improve our rules and our response, and as well as laws that are being proposed. Thank you.
Thank you, Judge Hawk. And then finally to position 1, starting with Mr. Edwards and closing with Justice Melody, please.
Am I unmuted now?
Yes.
Okay. So thank you. I think this is an important question. It touches a lot of themes that we've been talking about tonight, including the rights that the Washington Constitution grants to Washingtonians those rights are broader than rights we see under the federal Constitution. I think it's important to emphasize they apply to all Washingtonians. Equal access to justice is one part of addressing this problem. It's certainly critical that our courts are open to everybody, but it's even more critical that they are fair to everybody. The research that's being done and some of the data that's being collected that was being talked about are going to help to educate judges and legislators more about the problem and help inform future solutions to improve this on the solutions that are already underway that you've heard talked about so far. There's been a lot of reference to the letter, but no specific discussion of the contents of it. So I'd like to end just by reading two quick sentences from it that I think we should all agree with. As lawyers and members of the bar, we must recognize the harms that are caused when meritorious claims go unaddressed due to systemic inequities or the lack of financial, personal, or systemic support. And we must also recognize that this is not how a justice system must operate. Thank you.
Thank you. And Justice Malady, please.
So I agree with that. And, I sit on the Rules Committee. I'm glad that I'm going to have so many future colleagues on that committee because it's really hard work. And I volunteered for that committee for exactly these reasons, because that June 20th letter, when it came out, June 4th, 2020 letter, when it came out, was so refreshing, not because you rarely hear judges saying our own institutions, the ones that we run and operate and live in, have systemic racism embedded throughout them that continues to harm the very people who we are committed to serving. And that's just, it's true, but it's so rare that a court especially acknowledges that. And so that was, you asked what was my reaction to the letter. As a civil rights lawyer, that was my reaction to that letter. And then now as a judge, my responsibility is to make that commitment real. That letter came out 6 years ago, and the court is doing sort of, has and is going to again do work to refresh our own commitment, see how we're doing. What metrics are we working on? How are we staying true to this commitment? Because it's one thing to talk about it, and it's another thing to do it. In 39 counties, on the Rules Committee, in the Gender and Justice Commission, which I'm also a member of, on the Minority and Justice Commission, which the court oversees, the important interpreter work that Judge Diaz chairs. These are all elements that you have to keep all these balls in the air all the time, or you're never going to make progress towards getting to that mountaintop of improved access to justice for everyone.
Thank you, Justice Malady. I want to thank all the candidates for staying almost remarkably right on time. We are at the point where we're going to move into closing statements. We had originally planned to spend 90 seconds on closing to try to stay on time. If we could possibly get those closer to 1 minute, that would be fantastic. But I understand that's a last minute change, so please just do your best. We will go in the reverse order as we did opening statements. So starting with position 5, 4, 3, and 1. So closing statements, please, beginning again with position 5, and we'll go Judge Amamilo, please, followed by Justice Angelis and Judge Larson.
Thank you, and thank you for this rich conversation this evening. Our Supreme Court plays a critical role in ensuring that the Constitution and the law are applied consistently across Washington. And I've seen our courts from every level of general jurisdiction, including appellate review of state agency decisions under the Administrative Procedure Act, mental health court, which includes involuntary commitment, adult criminal, juvenile criminal, child welfare, and all manner of family law cases. These cases carry impact across all 39 counties, and I have also had the opportunity to serve as a pro tem judge at Division II and experience that process of collaborative decision-making. I've also spent years presiding over cases involving children and families, including complex matters involving child welfare. As I indicated before, termination of parental rights is the death penalty of civil law, where you as a parent lose your identity as a parent. And that is very important to me that we take those things seriously. But in a 9-judge court like Thurston County, each judge is typically responsible for thousands of cases over the course of a year, and that includes multiple hearings, which impacts a greater number of lives than the raw case count suggests. And the strength of our courts is measured by how well we serve every community across our state, urban and rural, large and small. And just as important, I approach every case with a commitment to trauma-informed and respectful process, because consistent application of the law, paired with how people are treated, is what builds trust in our courts. And to be fair, and to be sure, the appellate record is from the trial court. It is not a newly developed record. And as a trial judge, I've decided thousands of cases, as I indicated, affecting many thousands of lives, working to ensure that every community, including Yakima, can rely on a fair, consistent, and respectful court. Please vote Sharonda Amamilo for Supreme Court, Position 5. Thank you, and thank you for
Thank
your
you so
time.
much. Moving to Justice Angeles, please.
Thank you. And let me just first say thank you to the Yakima Democrats. You have assembled a remarkable group of individuals who are attending this meeting. Some of my absolute heroes from our court, former members of our court and the bar are attending. So thank you so much for making this happen. The Supreme Court is a team. It is a team where each member brings different strengths and where each member has different focuses. So what I want to do, continue to do with my time on the Supreme Court, is make sure that that access to justice is not a luxury, especially for civil legal issues. I've spent a lot of my career thinking about civil legal aid, thinking about access to justice for individuals who are injured or harmed and have no effective redress. So our court has powerful tools to make this happen well. I want to revisit our technological solutions. I want to revisit our limited legal technician programs. I want to revisit the way in which we for justice to everyone who appears before us. So there's a reason Justice Melody and I have our email addresses on the court website. We want to hear from you. Send me an email with your ideas and thoughts, and we will be responsive to you. Thank you so much.
Thank you, Justice Angeles. And moving to Judge Larson, please.
Thank you again. I echo Justice Angeles's comments about putting this together. We need more of this, and that's certainly going to help people have a better feel for who to vote for judge. The case I talked about earlier, the wrongful death case, that case shocked me into a different lifestyle, different way of approaching the law. There was a case where my client killed a 12-year-old kid, and to make it short, the story short, it turned out the mother did not believe my client acknowledged her son's death. My client turned out wanted to talk to him. The school chaplain said not to. My client stood in the back at this 12-year-old's funeral and planted 2 trees at the kid's school. There wasn't a dry eye in the house, and the parents settled for $40,000 on $100,000 limit because of liability issues. All they wanted was dignity and respect. I witnessed other things like that over the years. I almost walked away from the practice of law because we started focusing more. I've been around this 44 years now, 3 years working in law school and 41 years as a lawyer. We got slowly crept into more litigating rules instead of people. An example is tonight. Everybody here is great and well-meaning. We talked a lot about statutes, rules, committees, commissions. When did we talk about people and how we affect people? And that the reason I'm running so often is because that hasn't sunk in. Now I've had my career threatened. I've been labeled an ideologue. I've been all kinds of things. But this is great because I get to address people directly. Why I continue to run, because I want our system to be what it should be, that delivery of dignity and respect. The reason I didn't quit the practice of law, it's a calling. We're supposed to be the lighthouse in the storm and not a ship lost at sea. We're supposed to be the example to people about how to solve problems. Many of the issues we see in greater society relate directly to how we've allowed our justice system to devolve into a battle or into a war rather than delivery of dignity and respect. And
Thank you, Judge Larson.
Thank you.
Thank you. Appreciate it. Moving to position 4, Judge Burke, followed by Judge O'Donnell, please.
Yes, thank you to the Yakima Democrats for putting this together. This has been wonderful. I will be brief. It's getting late. I have made my life and home here. I am a 5th-generation Washingtonian, and I care deeply about the people of this state and who call it home. Judicial independence is the cornerstone of democracy. It is the most important consideration in the mind of voters this fall. We need our judges to decide cases based on law and fact, not politics or pressure, and uphold equal access to justice. That is the heart of the rule of law. It's why I'm running, and I thank you for this opportunity and look forward to earning your vote. Thanks very much, and good night, everybody.
Thank you, Judge Burke. We'll move to Judge O'Donnell, please.
Thanks, and thanks for a great event tonight. I wouldn't be doing this without the support of my wife and my kids. They are the fuel that makes me want to run. But we're at a pivot point for this court, and I think together we can do this reset in a way that our court is, as you've heard, fair, impartial, hardworking. I've been rated exceptionally well qualified for this position. I've served as a pro tem justice on the state Supreme Court, and I have endorsements from across the state, over 200 judges, mayors, public safety officials, lawyers, and elected leaders you'd recognize, including Governor Gregoire. I have a record of consensus building, and that's what I want to bring to this Supreme Court, and that's what I will bring. And I will be dead set against AI justice taking over human judgment. O'DonnellForJustice.com is my website. I would appreciate your endorsement and your support. Thank you so much.
Thank you, Judge O'Donnell. And let's move to position 3, starting with Judge Diaz, followed by Judge Hawk.
Thanks so much, Professor Levin. Thank you to Nancy and Natalie, and thank you especially to all the participants. I think we had up to 175 people, and remarkably, 127 are still hanging out with us. It's just really wonderful. And I guess I just want to end where I began, which just so you can get to know me a little bit. I'm a working class Latino immigrant with indigenous roots. I was a federal civil rights lawyer who fought to defend the rights of all people, including service members and the most vulnerable. And for that work, President Obama nominated me to be a federal judge. And finally, I was both a trial court and appellate court experience. I have both trial court and appellate court experience. I think it's for these reasons that I've been endorsed by so many of the local Yakima judges. That includes Elizabeth Tooch, Sonia Rodriguez-True, Shane Silverthorne, James Elliott, Jared Boswell, and David Ellefson, who many of you probably know, who's a retired judge. Because I think they believe that I'm ready on day one. And what am I ready for? I'm ready to continue to uphold the rule of law, open up the courts to all of our Washingtonians, and do so in a spirit of service and humility, so we can continue the American dream, which is really under threat for another generation of Washingtonians. So thank you so much, everybody.
Thank you, Judge Diaz. And Judge Hawk, please.
First, I want to thank you, Professor Levin, for moderating the discussion tonight. And again, thank you to the Yakima Democrats for hosting this forum. Elections for Supreme Court justices have never been more important. My entire career has been defined by advocating for those most marginalized and those who lack power and resources. I have spent my legal career protecting the constitutional rights of individual Washingtonians. I have done that both as a state and federal defender and doing civil rights work at the ACLU of Washington. As an attorney and now as a judge, I have worked to eliminate bias and barriers to the legal system, address unmet legal needs, and provide greater access to justice. As a Superior Court judge, I do everything in my power to effectuate justice in the courtroom. And I believe that there is more that our courts can do to make the justice system more accessible and understood by the public. I am endorsed by over 100 current and retired judges representing 28 counties across our great state, and I am pleased to be endorsed by Governor Ferguson in this race. As a Supreme Court Justice, I will protect your rights and freedoms and the rule of law. My name is Jamie Hawk, and Judge Jamie Hawk, and I'd be honored to have your support in this campaign. Thank you. Good evening, all.
Thank you, Judge Hawk. And then finally closing from Justice Melody and Mr. Edwards for position 1, please.
Yeah, thanks to everybody for sticking with this. This is long. You're dedicated. I admire that. So I just love Washington. I bleed evergreen, right? I'm a Spokane girl, only public schools, University of Washington, and now I have a kindergartner and a second grader who are in public schools too. So Washington educates my family, it keeps us safe, and I'm really focused on Washington values and Washington history as I do this job because we are in a special place in this corner of the country. And so it's my privilege to be your public servant. I've never applied for a job for a client that pays me ever once. I've only ever worked on behalf of you, the people, our community, my neighbors. And so it would be a privilege to continue to bring sort of independence, hard work, rigor, and impartiality to this role. And it would be a privilege to continue to serve you on the Washington Supreme Court. So I hope to earn your vote. Thank you.
Thank you, Justice Melody. And Mr. Edwards.
So I want to thank the Yakima County Democrats for organizing and hosting this forum so that voters can learn more about candidates to this important office. I should have recommended more of these types of forums as a method for improving voter turnout. So I hope to participate in more of them. I recognize that this is a Democratic Party meeting, and I appreciate that the organizers have been very careful to make sure this is a nonpartisan event. The role of the Supreme Court, of a Supreme Court justice, is nonpartisan. Our government is based on separation of powers, with the Supreme Court's role to apply the law equally to everyone, regardless of race, gender, wealth, status, geography, or political belief. It is critical that the credibility of the court, that those who serve on the court are independent from political parties and apply the law as written, consistent with the Constitution. Our judges need to both actually be fair and be seen to be fair. As a Supreme Court justice, I will continue to bring my principled approach to an independent application of the law. You can find out more about my campaign at votescottedwards.com. Thank you.
Wonderful. Thank you all so much to our candidates. And again, thank you so much to the Yakima County Democrats, and for folks online who I know gathered statewide, and then also with the viewing party in Yakima County. So again, thank you for sticking with this ambitious and wonderful and informative program. Have a wonderful evening and take care.